good morning, and thank you so much for joining us for this week's webinar, Post-COVID-19 Pivot to Digital Adoption, Trending Legal Considerations. My name is Raj, and I will be your moderator this morning. Now, digitalization is imperative to kickstart businesses and operations as we prepare for the new norm of doing business post-COVID-19. Well, it's also important to build resilience to face future challenges. Now, recognizing this importance, many businesses are rushing into going digital. It is so difficult to keep up with what's trending. I mean, everything from internet sales, HR processes via cloud computing, smart contracts and cashless payment solutions, and local tracing apps. The opportunities are endless. Now, for our webinar this morning, we have assembled a team of experts, our Avengers, to talk to you about the digital trends in the region and also what are the legal and regulatory speed breakers that businesses must watch out for. I'll waste no time introducing you to the speakers. First up, Jonathan Lim. He's a partner in ZICO Malaysia's Technology, Media and Communications Practice Group. He lives and breathes Fintech. He's actually the secretary of Fintech Association of Malaysia. Say hi, John.
Hi, thanks for the kind introduction, Raj.
Next is Jun Meng. Jun Meng is a director in our ZICO Insights Law Singapore. He's an M&A lawyer by day, but his passion is really technology, personal data protection, and digital tokens. He serves on the Information Technology Committee on the Law Society of Singapore. Say hello, Jun Meng.
Hey, hi, Raj. Happy to be here.
Okay, and then next up is Tay Zi Lee. He's a partner in our ZICO Law Vietnam office, and while he regularly advises on cross-border corporate and commercial matters, but he's actually found a passion on advising in regulatory and compliance relating to digital platforms. It's quite lucrative, isn't it, Zi Lee? Okay, so it's kind of a, I think it's kind of a boring panel because it's all guys. There's no girls in this panel. So yeah, but anyway, let's move on. Okay, there's a lot to talk about digitalization, but we only have 45 minutes or so. So what we've done is we've structured this webinar kind of like a buffet. We're going to give you bite-sized discussion points under 4 broad main topics, okay? The 4 topics are e-contracts and e-signatures, e-commerce and cashless solutions, fintech, and lastly, cloud and digital platforms. I'll be asking the panel some questions and they'll be discussing those points with us. At the end of the session, we'll have a 10 minutes Q&A session where I'll pick up some questions from you and throw it to the speakers. Please ask some difficult questions because trust me, they are well prepared for it. So please type in your questions and also your name and also address so that I can ask these questions at the end. Okay, and then if you're interested in any particular topic that the speaker spoke about, we can discuss this later after the webinar or just email us, all right? Okay, moving straight to the questions. John, are you ready? We'll start with e-contracts and e-signatures. Now, John, what are the type of e-signatures and are these enforceable? Okay, let me just elaborate on this. Now, assuming I have a company and we want to start selling products online via website, okay? My general counsel prepares a set of TNCs, which has an I agree tick box for consumers, right? Is that legally recognized as an e-signature?
All right, thanks, Raj. Okay, maybe let's break it into 2 parts in terms of the recognition of e-signatures and then I'll move on to the question itself. So historically, e-signatures are not entirely new in the market, right? In 96, you have the United Nations who actually published the UNCITRAL Model of Law on Electronic Commerce, which was highly influential in terms of the development of e-signature around the world. And that idea actually started off on the premise that they wanted to introduce a principle whereby it is that electronic form of documents will not be discriminated. They wanted to ensure that documents that comes from electronic forms are legally enforceable, it's valid, and takes effect eventually. And subsequently in 2001, the UN actually published UNCITRAL Model of Law Electronic Signatures guidelines. And as a result of that, many countries actually onboarded themselves and started enacting their own legislation to the validity of and enforceability of electronic contracts and electronic signatures thereafter. So Malaysia, we ourselves too jump onto the bandwagon. We have our Electronic Commerce Act 2006, which applies across board to commercial transactions conducted through electronic means. And that actually includes commercial transactions with federal and state government. So on one hand, on one side of the coin, we can easily say that electronic contracts are recognized through the ECA. And in the ECA itself, they continuously set that framework to ensure that how you will be adopting electronic signatures and what kind of electronic signatures can be recognized. And just to do a quick touch and go, the Act actually recognizes electronic messages whereby first it would require parties to consent to the form of electronic messages through commercial transaction. And explicitly in the Act, it says that consent does not require anything in writing, but it can actually be inferred through a person's conduct. But more importantly, the electronic signature that is used must identify the person largely, and it must be reliable, and it must be attached to an electronic signature. So I'm sure many of you have come across things like DocuSign, Adobe signatures, and technically if we premise back to the ECA, these electronic signatures introduced by DocuSign and Adobe are actually recognized under the ECA itself. Now, coming to your question, when it comes to certain occurrences whereby whether we go into a Play Store, whether we go onto a website whereby there is this little agree tick box or a TNC that pops out and say that click I accept to continue. These documents are what we commonly known as click wrap agreements. And if we bring that back to our local Contracts Act, the Contracts Act actually does not specifically require a party to sign off for an agreement to be valid. So by clicking that I accept, and so as long as it's identifiable to you, such T&C accepted by you would be binding.
Okay, answer like a typical technology lawyer, John. Now I want to ask this question to Junming. Now Junming, okay, so good points by John, but I wanted to ask you, so what are the contracts that can be signed electronically, and what are those that we cannot use electronic signatures to sign? Now, I'll throw this point to you as well. Please talk about smart contracts, because that's a sexy topic now, isn't it?
Yeah. Hi. So just continuing on from John. So in Singapore, what we have is the Electronic Transactions Act, which basically provides for the recognition and use of electronic signatures and electronic records. I believe it's very much similar to Malaysia because we also adopted the model law on electronic commerce from the UMSI trial. But I think, as John's mentioned, in most situations, contractual situations, the law doesn't actually impose any form requirements. And generally, a contract can be concluded by just showing offer and acceptance. And this can be electronic or done by wet signatures. And to answer your question, Raj, what are the documents that you can sign electronically? So this would be things like non-disclosure agreements, license agreements, most types of sale and purchase agreements, employment agreements, as well as internal corporate secretarial documents like your shareholder and board resolutions. But that said, you should still look at your constitution and observe the requirements under your constitution. And what kind of contracts should not be signed electronically in Singapore? Things like wills, declaration of trust, contracts for sale of immovable property. All these you should avoid using electronic signatures for now. But I think as Singapore kind of tried to digitalize, there's more effort to allow more types of documents to be entered into electronically. So right now there's some consultation on increasing the type of documents. So we might see things like trust and deeds, contract for immovable property, all these fall off after some time. So moving on to smart contracts, well, generally the Electronic Transactions Act is sufficient to cover smart contracts. And this is because if we look at smart contracts, they're basically built on blockchain. So the first question, I suppose, is whether blockchain is compatible with electronic transactions. And then the second part would be on smart contracts itself. So the Electronic Transactions Act does not actually prevent the adoption of distributed ledger technologies. And if we think about what when transactions are recorded on the distributed ledger, they are basically a tamper-proof electronic record of the state of affairs as well as transactions that has been recorded. So what the ETA here says is that information shall not be denied legal effect or enforceability solely on the ground that it's an electronic record. So that's the first point that gives kind of a grounding to blockchain. The other thing is that a lot of the concepts under the Electronic Transactions Act, things like electronic signatures, for example, blockchain transactions can actually fall under this. So John mentioned something about tying the identity of the electronic signature with, say, an individual or a legal person. So if we look at it in a blockchain context, data that was recorded on the blockchain is cryptographically hashed. So before it is written and stored into the blockchain. So this hashing is actually unique and traceable to a person. And on that basis, it is possible that you consider it as an electronic signature. And now onto the second part, which is smart contracts. So smart contracts is basically an if and then kind of idea. So they can automatically create contracts or create an action. So the Electronic Transactions Act in Singapore actually allows for the use of automated message systems, which basically means that if there's no human intervention when an action is initiated, and contracts that are formed via these kind of automated systems, again, will not be denied the validity or enforceability. Yeah, back to you, Raj.
Thanks, Junming. John, so it's clear. I mean, that electronic signatures, electronic contracts have got legal recognition. I think, yeah, that is quite clear. I just wanted to ask you this. Now, the question also is admissibility, isn't it? Because when you have an e-contract or an e-signature, what is important is these are admissible in court. Isn't that something very important? So technically, if I record my voice on WhatsApp saying I agree, and I send you the recording, that recording is admissible in court as my acceptance of the contract. Is that correct?
Yeah. So Raj, that's a very that is a very interesting question, because most of the time the emphasis is always looking at whether the electronic signature, or to a certain extent, some of us will even confuse ourselves with a bit of like the digital signature that was published by MCMC, which is slightly different from what we discussed earlier. When it comes to admissibility, as mentioned earlier, under the Malaysian law, that there is no strict requirement whereby a handwritten signature is required to validate a contract. If we look back into our Evidence Act, and back in 1993, I think our laws were amended to receive electronic evidence. And under the Act itself, electronic evidence includes things like computer-generated produced documents, computer printouts, computer outputs, computer-based evidence, electronic data, and electronic documents itself. But of course, over time, I mean, we're talking about since 93 till now, there are so many changes in terms of technology, and now there's new sub-emerging categories like chat rooms, or your WhatsApp chats, or web browsing histories, or ISP records at the end of the day. And we also note that there are certain countries that recognizes the use of certain software to secure digital evidence by conducting digital forensic experts. But localizing it and then looking back into our Evidence Act, we can definitely rely on Section 90A, whereby a document produced by a computer or a statement produced by a computer shall be admissible. And under the Evidence Act itself, it actually defined document to actually include sound recording or any electronic, magnetic, mechanical recording whatsoever that creates electronic impulse. So to keep it simple, our Evidence Act is actually rather up to date, and it actually encompasses enough to even include certain sound recordings whereby if we premise back to the traditional formation of contract as an offer and as acceptance, and there itself can be proved. In short, I would say that the courts will recognize such contracts.
Thank you, John. Okay, Zili. So we have what we have is you got legal recognition for e-contracts, e-signatures. You've got admissibility of e-contracts and e-signatures. Now, I want to ask you, what are governments doing? Now, are governments making it more conducive for businesses to use e-contracts and e-signatures? And in your experience, are there more stringent rules for e-contracts and e-signatures as compared to printed contracts and wet ink signatures? Over to you, Zili.
Hey, thanks, Raj. I think we heard from John as well as Jumaine on the legal positions for Malaysia and Singapore. And it's also worth noting, John has kindly introduced to the audience as well in terms of the UNCITRAL model law on electronic commerce, which I will just add on that most of the countries in ASEAN has actually adopted that. So even for Vietnam, for example, the law on e-transaction was actually passed in 2005. And which then we have a new guiding decree that was actually issued in 2018 to basically govern the implementation of the law on e-transaction regarding the digital signatures as well as the digital signature certification services. Now, again, as John has briefly mentioned earlier, the point really is if you are a so-called, you have adopted such model law, ultimately you are looking at in terms of your jurisdictions to have the laws which are non-discriminative. So in the sense that having a contract being signed as an e-contract would not be discriminated against other forms of the physical contracts that we are typically signing. So this is to say that there are technically no such difference whether you are signing it via an e-contract or signing it via a physical contract. Ultimately, you just need to be ensured that there are two key principles that you have adopted to, i.e. the integrity is ensured since its first creation, and then the content itself is accessible and usable in a complete form. So moving from this, will this be subject to a more stringent rules and requirements? That is not, because you have the laws have already laid down the foundation to that. But I would just like to add on a point now that the companies are thinking of, or they are moving towards executing more agreements in this space. That is the retention of such e-contracts. Because ultimately, in terms of the physical documents that we have signed at this juncture, it is being properly stored and documented. But in terms of the e-contract itself, the companies would then need to basically have a standard operating procedures in terms of how these documents is stored. Because bearing in mind, you need to have the method of identifying the creation, the destinations, as well as the date and the person signing it and those. So there will be a set of rules, who is authorized to have access to this, to make sure that, these contracts are not being tampered with. And most companies, if they have not have these e-contracts being signed on a day-to-day basis, they may not have these procedures in place at this juncture. So for companies that are thinking to move towards executing more agreements via e-contracts, etc., the retention itself, they need to consider to basically have a standard operating procedure to retain such documents, to make sure that in case these documents are required for evidence in court, they are being properly stored. Back to you, Raj.
Okay, thank you so much, Zili. Zili, can I just ask you this one last question for e-signatures and e-contracts? Maybe take 30 seconds just to answer this very quickly before we move to the next bucket topic. Now, as GC, or if we are structuring a transaction or drafting contracts, now governing law clause is very important. Now, in the context of using e-signatures and e-contracts, do I have to keep this in mind that the jurisdiction of the governing law that I'm choosing is conducive for the e-signatures or e-contracts that I'm using?
Yes, Raj, absolutely right. So again, we go back to the questions of looking at the jurisdictions that have adopted this ancestral model law on electronic commerce, because more likely than not, such country would have the conducive laws in this area that properly govern this space. Thanks, Raj.
Okay. Thanks for keeping to the 30-second. Okay, so we've wrapped up the first bucket topic, which is e-contract and e-signatures. Next, we're going to go on to e-commerce and cashless payment solutions. John, I wanted to ask you first. Now, picture this scenario question from the client. Okay, so now client wants to sell using online marketplace or e-commerce platform. Okay, this means that the products will be sold to multiple jurisdictions, right? And as you know, different jurisdictions have different laws on product safety, consumer protection, and trade description. Now, does this mean the client has to look at compliance with laws of all these jurisdictions where the products are going to be sold to? Now, how does the client go about in terms of ensuring compliance?
Quite a big question, Raj. Okay. Anyway, let me try and take this question in the context of Malaysia first. So in the context of Malaysia, when it comes to e-commerce or sale of goods, traditionally or not, the provision, when it comes to conducting businesses online, we have to refer to a set of legislations that's being provided. And as we mentioned earlier, there's the Electronic Commerce Act, there is the Personal Data Protection Act. We have our own Consumer Protection Act, or we even have our Consumer Protection Electronic Trade Transaction Regulations, Trade Description and Sale of Goods Act. So if you're conducting businesses in Malaysia, whether it's online or it is offline in itself, these are the legislations that generally you would have to adopt. Of course, as you mentioned, in different jurisdictions, there could be certain tweaks or certain differentiation to our mainframe of legislations that we have in Malaysia. But to a large extent, these legislations that are put in place are somewhat similar. As you can see, as from even the electronic signature itself, as Zili shared, as Junming shared, there are similarities in terms of the legal framework in itself. However, so on the point I'm making is that it is firstly very important to ensure that the framework or the legal framework that you're adopting here in Malaysia is set clear in place as good practice standards for you to embark on multi-jurisdictional marketplaces. But a point that I want to note here is that there are certain products or certain services that perhaps require a little bit more attention or a little bit more due diligence, whereby it is very useful to then embark or engage a local counsel to look into. And these services technically or products is largely made out of things that involves medicine or medicinal products or medical services, or even services that involves gambling, or services that involves tobacco products or advertisement of deposits. These are highly regulated services or products, regardless of whichever jurisdiction you're in. And as maybe for an example, we can take it to say that in Malaysia, when it comes to a gambling or a product or advertisement of a gambling product, is prohibited under the Common Gaming House Act 1953, right? And you definitely need a license from the Minister of Finance to do so. But I'm sure that the position is slightly different in Vietnam. The position is slightly different in Cambodia, and in Philippines. I think, if I'm not mistaken, they still have available licenses, and they do have different regulatory bodies for it. So as a whole, what we have here in Malaysia continues to create the very set of skeletal guidelines for us to embark on different jurisdiction. But when it comes to things that are a little bit more hazardous, things that are a little bit more health related, we would always advise to seek their local counsel just to see what are the different legislation that could be imposed.
Thanks, John. You said the question was difficult, but you answered and you threw in an elevator pitch there. So okay, that's a good one. Okay, I'll move on to Junming. Junming, now just following on from what we asked John. Now if I wanted to use my company's website to sell products online, right? So what, in your experience, what are the key legal and regulatory issues that a GC needs to think about?
Yeah, thanks, Raj. I would pretty much echo most of what the points that John raised. I think it's really important to check whether, say you're importing a new product, whether you can actually import and sell it in Singapore or not. As John mentioned, a couple of products, they are controlled medicinal products, gambling, tobacco. I think it's pretty much the same across many jurisdictions. So in Singapore, you have to look at, say, the regulation of Imports and Exports Act. There's a list of prohibited and controlled goods. But the thing here is that all these restrictions are kind of spread out over a variety of statutes. So as John said, it's always best to check with local counsel. The other thing I wanted to touch on is the way the business sells the products and market the products. I think when many companies move towards e-commerce, all of us on this webinar, at some point, will have received an advert that just sounds too good to be true. So I think it's important for businesses to know that there are some unfair trade practices that's in the Singapore Consumer Protection Fair Trading Act, and think about how to market their products legally. So for instance, your advertisements should not mislead consumers about promotions or discounted prices. So say if you say your discount is limited for 2 weeks, it should not keep running for 2 weeks and then 4 weeks and 6 weeks. That will be considered as misleading. Another example is when you show discounts, the real previous price should be used for comparison. And if you're saying something is free, you should stay upfront if there are any qualifiers, terms and conditions, or even subsequent charges. The other thing I wanted to touch on a little bit is marketing on social media, because I think we're seeing more companies using influencers, media personalities to promote their products. So again, there are guidelines for this. If you are using social media like blog owners, influencers to advertise or market your services or goods, it should be stated clearly and prominently that the content is in fact sponsored, right? The aim here really is to distinguish between what's personal opinion and sponsored content. The last thing is that marketers should not boost user engagement of a website or post by purchasing likes or creating fake accounts or using some kind of bot that generate page views. So these are the few things that I would encourage businesses to think about, Raj.
Thanks, Junming. So who is the new hottest influencer in Singapore? Okay, don't answer the question. I'm going, Zili, the next question is for you. Now, going cashless and contactless payment solutions are the in thing now, right? I mean, you can't avoid this. What are governments doing to promote this cashless and contactless payment solutions for businesses? Are there conducive regulatory frameworks in place or in the pipeline?
Well, I will answer this from the Vietnam's perspective first. Yeah. So actually for Vietnam, there's no clear legal definitions in terms of the description of e-payment or contactless cashless services. So the framework in terms of the Vietnamese law that we have existingly that has been passed is the payment services via the payment accounts, the payment services not via payment accounts, and the intermediary payment services. While the first two are actually only available to the commercial banks or the foreign banks branches, which are not available to any of these what we call the e-wallets, etc. Right? So it's only left with the so-called intermediary payment services, and this is what some of the e-wallets provider, for example, the Zalo Pay, the Momo that has been vibrant in Vietnam, that they have. So one thing to note is that Vietnam, despite being one of the hotspot for investments, and we see Vietnam growing at a very fast rate as compared to some of the other countries, the cash transaction in Vietnam itself still dominant the market, i.e., if you look at the statistics, non-cash transaction in Vietnam per capita is actually the lowest in ASEAN. So this brings us to means that there are a huge space for the development in this particular space. And what we have seen is in the recent times is that the State Bank of Vietnam has actually passed on the so-called a pilot program as well as the draft decree to basically pushing for mobile money, right, to be passed. And the last we heard from the Prime Minister speech is that such pilot decision has already been contemplating at this juncture. So what this mobile money, how this mobile money works is that it is unlike the mobile wallets, the examples that I've given earlier, whereby it requires the user to transfer money from a bank account to such wallet. This mobile money, basically, the user would only need a mobile account, meaning your handphone, your mobile account, to carry out the small amount payment. So this is one of the way where the Vietnam government is actually pushing for this space. And this was actually a targeted approach because only about 50% of the Vietnamese has a bank account, but more than 90% of the Vietnamese have mobile services. So there's a huge gap between the public having bank account as well as the mobile services, and which is why having such mobile money will actually surge the growth in this particular area. And we are following closely in this space. And the last we checked is that the big telecommunication services provider in Vietnam, for example, Viettel, Mobifone, they have all supplemented such payment intermediary into their business lines. So, they are paving way towards participating in this mobile money market. So we will see this space continue to grow. Back to you, Raj.
Thank you, Zili. So that brings us to the end of that bucket. And before I move to the next bucket, which is fintech, I can see John smiling already. Thank you so much for your questions. I have all your audience questions with me. I will pick out some of these questions and to ask the speakers after this. So please keep the questions coming. Okay, so let's go to fintech. Now, John, you wrote an article recently titled "Fintech's Virus Silver Lining." Now, thriving fintech companies largely premise on two key principles. One is finding a plausible problem statement, and then providing a user-friendly solution to that. Now, this is my question. Can you look into your crystal ball and tell us now, what do you think is going to be the strong fintech products coming out of COVID-19 pandemic, and how are fintech companies going to solve these problems?
Right, thanks, Raj. Crystal ball, I think crystal ball will be kindly email Junming, Zili, and I after this, and we'll let you know what's. Okay, honestly, there's no real crystal ball that we're looking at, but I think over the trend, and I'm sure also echoing from Junming, and in terms of the development of how Singapore has been over the past 3 to 4 years, fintech has been really thriving, and fintech has really been the new sexy norm that everyone's talking about. But if we were to assess the market as a whole, maybe I can look at it now with having the pandemic around us. We will split the entire market to two sets of individuals, which is one set being the entrepreneurs, the other set being the consumers. And as for entrepreneurs, I will include things like investors and even consumers itself, right? So as we continue to adjust to this new norm, what is permeating the market very much now is the sense of fear. And hence, I think we've been reading many articles that talks about, with blazing headlines that talks about cash is king, or Bitcoin, the resilient currency, or conservation is the way to brave the storm at the end of the day, right? But from this kind of observation and purely personal, on my personal view, I would say that traditional enterprises, when it comes to buying, selling, when it comes to investment, everything's going to start to change. And the change will be very prominent when it comes to ticket sizes. I think in the next couple of months, 6 months to 12 months to go, you look at multiple investments, but maybe smaller ticket sizes now. And what does that actually translate to when it comes to the fintech industry? So let me tier it a little bit. So central bank whether it's Singapore or Malaysia, we've been propagating really hard on virtual banking or digital banking, right? We had the European continent that started it, then we had Hong Kong following suit, then Singapore has that license, and then Malaysia also wasn't far behind, and we're really pushing forward to talk about virtual banking. But yes, I agree. Virtual banking could be very exclusive to a set of private families or to a set of equity fund holders, because the ticket size is very large. You need 100 million from Malaysia to kickstart this application at the end of the day. But as we look at the growth or the expulsion of this tier 1 digital banking space or virtual banking space, it will also mean that we will trickle down to tier 2, tier 3 supplementing fintechnology or fintech players at the end of the day. It opened rooms for like credit assessment fintech companies, it opened rooms for insurtech, it opened rooms for even remittance houses. And on another vertical, we start looking at contact or cashless payment, but rather cashless payment has now taken another leap to contactless payment, right? And a couple of years back, I was very intrigued when I heard about this company called Acorn that was coming into the Southeast Asia market. And what Acorn does is that they do micro investment. And to keep it simple, what they do is they round up your credit card transaction, and the little roundup that they do, they put into an investment fund. So what I'm trying to say here is that as we look into this new norm whereby technology becomes the underlying foundation for most things, it's merely a transformation of traditional businesses in adopting how they can digitize it to move forward. So I would not be surprised to see in time to come that digital factoring will be something that's going to be new. P2P and ECF, which I think I must take my hats off and give credit to SC, especially recently SC has expanded the RMO to include things like e-platform for services, the digital asset exchange, all these kind of initiatives that has been brought about merely translate to two things. One, we start introducing cluster investment. Junming was sharing up a little bit on smart contracts, and that leads a lot to tokenization. That leads a lot to the issuance of cryptocurrency at the end of the day to a certain extent. And these actually basically tells us that now if I have 100,000 ringgit, I no longer need to take this 100,000 ringgit and park it into one portfolio. I can break my 100,000 ringgit into 10 smaller portfolio sizes and start investing. So maybe maybe from what I've just shared, it sounded like I talk a lot about the money market, talk a lot about the slightly more complex capital market products or lending products that's in the market. But over the MCO, I also observed something, and that will be echoing from what Junming has just shared. I've been buying online deliveries for clients and friends, and I think we just had the recent Chinese festive on the glutinous rice wrap, the Bachang festival, and I trampled upon a social media platform whereby, lack of a better phrase, a couple of aunties actually posted a little advertisement on whatever bachang they have. And I thought, wow, it is so hard to get these kind of things nowadays. And what more, I'm locked down in my house, suffering from cabin fever. How am I going to be actually accessing these kind of things? And social platforms, yeah, indeed became my access. And I would say that these aunties has taken that leap to digitize their little business, just to publish it on whether it's Facebook or Instagram or any of these social platforms. That allows me to then buy, and they pair it with all the delivery boys like Lala Move or Ninja Van or all these kind of guys, and there you go. You just created another set of business based on a traditional form of how we used to trade.
Thanks, John. I'll ask you for the advertisement on the aunties later. Okay, Junming. So what's happening in Singapore? I saw you smiling when John was saying cryptocurrency is the resilient currency.
Yeah, because a lot of people have been saying that it's far more resilient than traditional equities. But in Singapore here, I think the biggest development early this year is the Payment Services Act coming into force. So the Payment Services Act basically covers the regulation of e-money issuers, merchant acquisition, cross-border money transfers, and most notably to me, digital payment token services. And I think this regulation on digital payment token really helps to legitimize, say, the cryptocurrency industry or digital tokens here in Singapore. But beyond cryptocurrencies, I think it opens up a lot of opportunities in fintech and digitalization in the form of tokens. And I think when we talk about tokens, it's unavoidable to speak a bit about blockchain. In Singapore, the blockchain ecosystem here is far more mature. Now we have custodial providers, exchanges, digital security exchanges. There are people that are consulting enterprises on how to use these solutions. The regulators as well have looked into this space. So the MES has what we call Project Ubin, which is now in phase 5. The IMDA authorities are also looking at how to get enterprises to make use of blockchain more to improve and transform their businesses. Yes, granted, blockchain is not right for all kinds of businesses. It's not the right solution for everything, but it can reduce a lot of friction for certain things like transacting money and handling payments. And I've done a couple of tokenization kind of projects for things like gold, loyalty points, shares. And I think the interesting thing here is that all the legal issues are really different. So if any of our listeners are thinking about a certain use case or exploring whether blockchain is suitable for you, for your process, I'm happy to think through the legal issues with you.
Thanks, Junming. Yeah, I've got Zili. The next question is for you because I got 1 or 2 users to say asking me to ask you more questions. I don't know why, but never mind. Okay, so Zili, I wanted to ask you in terms of in Vietnam, right? So what are the key developments in Vietnam in terms of fintech that you're looking at, which I want to touch on? So you mentioned earlier before the webinar that based on ASEAN Fintech Census 2018 from EY, Vietnam currently ranks second among ASEAN members in terms of incubators, accelerators, and innovation labs in the region. Now, what are the main drivers for this growth in Vietnam, and how do you see the development of fintech space post COVID-19?
Thanks, Raj, for the question. I think first I will just do a bit of comparison with what John and Junming had shared earlier. So for example, John touched on the digital bank that Malaysia is pushing for it. And we read the news that even Axiata is contemplating to apply for such license and those. Vietnam actually has our digital bank since 2016. So now we are into 4th year of having a digital bank. So I mean, on this particular space itself, seems like Vietnam is moving slightly faster as compared to Malaysia. Whereas Junming touched on a little bit on cryptocurrencies, tokenizations and those. And Vietnam is actually at a crossroad on this because there's no clear regulations in this particular space, and the government is still contemplating where to move from here in terms of the cryptocurrency. How do they regulate that? So it is still a work in progress. Whereas, as Junming has mentioned, Singapore has developed way ahead as compared to the other ASEAN countries. So the development of the fintech space post COVID-19 itself, we can safely say that Vietnam is doing very well in terms of containing these virus. And when we will see, Vietnam has actually reopened up the market, right? And I think I will tackle this from a macro level first. Vietnam continue to have a high GDP growth. So we will see that some countries may have negative GDPs growth. And for the first quarter itself, Vietnam still positive. And the high GDP growth is expected to continue for the rest of the year. Vietnam continue to have competitive labor costs. 70% of our population are under the age of 35. There are more than 1 million of a new workforce coming in annually. So it will continue to develop, right? And if we want to zoom into the fintech space specifically, I think there are a few growth drivers that we are looking at. But to me personally, I think the most important part is education, right? So the government has actually introduced a specific subject called the Science, Technology, Engineering, and Math that basically teaches the students in terms of the computer science and basic software development and programming. So these are mandatory curricula that the Vietnamese students have in school. So meaning after they graduate, they have these basic software development and programming skills as part of their curriculum. So this is one of the initiatives that the government has pushed for this, and I think this will continue to drive the growth of fintech in this space. And obviously, we do see the government support as well. Vietnam has a National Agency for Technology Entrepreneurship and Commercialization Development, a specific body that to drive this particular space, as well as there are further tax incentives being provided for the fintech players as well. So yes, I'm very optimistic in terms of the development of fintech space, and Vietnam will continue to grow in this particular area. Back to you, Raj.
Thanks, Zili. Okay, so we are coming a bit to a time crunch, and we have one more discussion topic bucket to go to, which is cloud and digital platforms. So what I propose to do is actually to merge some of the Q&A questions that I'm getting from the audience and actually ask them to the speakers, all right, in terms of cloud computing and also personal data protection. I've got a few questions that are coming out from in relation to personal data protection. Now, John, I want to throw this question to you. In terms of migrating to cloud computing, right? Okay, so there's a scenario here is that my wholly owned parent company in Germany actually bought this new B2C sales and marketing platform. Now, the parent company wants all subsidiaries, including my company in Malaysia, to upload all customer and vendor data into this cloud computing system, right? Question is, no issues in terms of personal data protection, right? Because, well, it is my wholly owned parent, so no issues for me to transfer all the data up.
Okay. So to your question, Raj, I think, yeah, I think it's always been not uncommon that companies and its wholly owned subsidiaries often consider themselves as one group. And in terms of optics, strong company integration exercises will always generate the idea that, regardless of whichever subsidiary you're in, you're under one whole entire group. But when it comes to a legal perspective, each subsidiary is actually recognized as an independent entity on its own. And when it comes to personal data, especially under the PDPA in Malaysia, moving personal data from one entity to another will still require consent. In fact, there are specific provisions, right? When it comes to sensitive data, explicit consent is required. Things that involves like your healthcare and things like that. You actually require further explicit consent from the party before you can even start processing it per se. So taking that scenario at hand, and it seems to suggest that since the CRM or whatever tool that you're buying is going to be based in Germany, it suggests that there will be a migration of personal data. And then under 129 of the PDPA, such migration actually would again require consent from its data subject. So to that question, I would say that you would definitely need additional consent if it's already not provided in your employment contracts with your employees per se. But on the other side of the coin, I'd like to add, if the data itself is encrypted and the encryption data is being moved out of Malaysia and it will not be decrypted at this point of destination, then perhaps we do not need to, we actually steer clear from the PDPA. But if you encrypt it and you decrypt it again in an offshore server, definitely the PDPA will apply again.
Thanks, John. Okay, Junmei, another question from one of our audience, and I'm just going to paraphrase a bit. So you've got a lot of businesses now adopting webinars like us, right? And having like boutique gyms going on the internet to stream workout sessions. One of the fashion companies had live stream his catwalk cat shows for 2020. Okay, now so with all this use of virtual and also virtual platforms, there's also the scary stories about Zoom bombing. There's this Mobi Friends online dating app which had about 3.6 million users, data leaked on the internet. Now, the question is this: what are the exposure in terms of liabilities for a company where there is hacking or data breach incidents? What kind of liability are we looking at?
Yeah, so data breach is a big topic now. In Singapore, currently, with the current regime, it's not compulsory for you to report a data breach, but it will soon be mandatory in the latest proposed amendments. So I think the first thing to do is when a data breach occurs, companies should quickly assess whether notification is required. You should record the steps that you have taken and act quickly. So generally in Singapore, the notification must be done within 3 calendar days, 72 hours kind of thing. After you determine that the data breach meets the notification criteria. So when do you need to notify? Two situations. If the data breach is likely to result in significant harm and impact. So examples of personal data will be things like identification numbers, credit card information, medical history. And the second scenario where you should notify is when the breach is of a significant scale. So things like the rule of thumb is more than 500 individuals affected. So Raj, on your question on penalties, under the current regime, the regulators here can impose a financial penalty of up to $1 million for data breaches. But in the latest amendments, they're going to revise this, increase it, obviously. The maximum financial penalty will be increased to up to 10% of the organization's annual gross turnover in Singapore, or $1 million, whichever is higher.
Wow, that's in line with EU GDPR, isn't it? Quite heavy penalties.
Yeah.
Okay, I've got another question from one of the audience, and let me just take this question. So the question is this: when players within an industry collaborate to build a platform so that they can use the industry players can use the platform to market products or to sell products, are there any competition law issues? I thought this is an interesting question because at these times, everybody's trying to save costs, trying to collaborate, trying to make sure that they don't spend too much. But in doing so, do they run foul of the Competition Act? Now, the simple answer to that is yes, there is a risk, because when competitors get together and you exchange sensitive data, for example, pricing or trading terms or supply, that sort of kind of information, that can expose you to competition law risks. And of course, the penalties for that is 10% worldwide turnover of the enterprises infringing the Competition Act. Okay, so that brings us nicely to wrap up the cloud and digital platforms topic. This is one question that's come up, which I would like to throw to Zili actually, because it's really trending. I've read a lot about this, and I think the audience really like to know in terms of virtual AGMs and EGMs. Now, Zili, this is kind of hot at this point in time. Now, what are the issues you are seeing in terms of having virtual AGMs and EGMs?
Hey, thanks, Raj, for the question. I think it was just yesterday when one of the Malaysia largest developer, ZICO, has their AGM, a listed company in Malaysia, has their AGM, basically virtual AGM online. So the listed companies are already doing that. And we've seen in Vietnam as well, Nam Long Investment Corporation, a major company in the real estate business as well, had their AGM. And even a bank, one of the biggest commercial bank in Vietnam, Sacong Bank, has also basically decided to have its AGM online next month. So it is like what you say, it's really trending. And the key legal issue is whether the constitution of the company, or in Vietnam, we call it the charter of the company, whether have you specifically allows for it. Because the law itself actually provides that you can actually have an online or virtual meetings. And then the question goes to whether internally for the company's record, whether you have that on board or not. So for companies that are contemplating to do that, it might be worth checking in, whether your constitution at first instance allowed it for or not. And if not, then perhaps it's time to basically amend your constitution and charter to make provisions, because in the future, this might be the way moving forward. Thanks, Raj.
Thanks, Zili. Junming, I have one question from the audience. This relates to e-signatures and e-contracts. Now, do we have virtual commissioning of oaths and notarization? How do we notarize an e-contract?
Yeah, so very quickly, commissioning, it's possible by video conference now in Singapore. The commissioner of oath will basically verify the identity of the person who appears and confirm that the person who signs is the one that's sworn and affirmed. Then on notarization, Currently, via video conference is not possible. So unfortunately, you still have to do it physically. That's all right.
Okay. Zili, one last question. Please take around 30 seconds or so to answer it very briefly, so then we can wrap up because we're at 11:55. Okay. Now, e-commerce has always been the popular platform in terms of internet sales. Just very quickly, do you think social media platforms will be the new thing as for businesses to move on to sell their products?
Well, as John has mentioned, it has already happened. So social media is the way to go, purely on the accessibility itself. And then for the social media platform, I think on their end, the risk would be that, as business continue to grow, potentially there are countries whereby they will start imposing, the per user kind of tax to basically tax them, since it's vibrant across the world. So yes, social media is the way to go. Yeah, moving forward.
Okay, guys, thank you so much. Now we come to the end of the session. This brings us to the end of the webinar. To the audience, thank you so much for joining us, and I hope you really enjoyed the session, because I did. I tried as best to take as many questions as I can from the audience and throw it to the speakers. But after this webinar, we'll go through the session and we'll go through your questions and we'll answer you after this. You can also email us if you have any pressing questions to ask us. Okay. The recording of this webinar will be sent to you in email and also available on our website together with more other resources. Also, please don't forget to join our next Wednesday's webinar. The title is COVID-19 Industry Impact by Business Leaders. The invitations will be sent out to you soon for those who have subscribed to our mailing list, and please keep an eye out for them. All right, so once again, thank you so much for joining us. Hope to see you next week. For my Muslim friends, Selamat Hari Raya and happy travels. Thanks. Bye.